Recording has started.
Good morning, everyone. I'm David Ammons, Chair of the Public Disclosure Commission, and I will be presiding officer for today's hearing on a number of cases in what we call the brief enforcement hearing process. And I'm joined by Vice Chairman Fred Jarrett, who is observing the process today. Welcome to speak or ask questions, but the presiding officer for this matter today is October 21st, and time is 10:05 a.m. The hearing is being conducted under the authority of RCW 3405, the Administrative Procedure Act, and relevant WACs and RCWs that are apply to these matters. The hearing is being conducted by teleconference in accordance with Governor Inslee's Emergency Proclamation 20-28 as amended, and we are being audio and video recorded. I would like to ask the staff present to please identify themselves for the record.
This is Tabitha Blacksmith, Compliance Coordinator.
Alice Feynman, Compliance Officer.
Jennifer Hansen, Compliance Officer.
Thank you. First part didn't come through.
I don't know about anybody else, but Teams is really slow for me right now. I'm having some technical challenges.
Fred couldn't get in. I don't know if one can handle that off while we continue working here, but that would be good. There are no one from the regulated community who wants on to Teams feed. Is that correct? You're muted, Tab.
My apologies. We do have some phone participants that will be calling in, but I think we can just add them at that time. Is that right, Tab?
Yes, that's true.
Okay.
Thank you very much. I would also at this time like to have staff who will be presenting today to please be sworn in. If you would raise your right hand wherever you are. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do. I do.
They do, and I appreciate that. We will move to enforcement matter that's scheduled for clock. Case 54838, Jennifer Tyler, presented by Alice Feynman.
As noted earlier, the respondent is not participating today, and I know, Dave, you have reviewed all the materials. In how much detail would you like me to go through?
I think just the bottom line would the summary of the violation that is alleged here, and we can dispose of it in that manner. Okay.
Jennifer Tyler the alleged violations are that her campaign violated RCW 4217A220 by receiving and depositing more than $300 in anonymous contributions from contributors and disclosing that information on a monetary contributions C3 report. And also the allegation that the campaign failed to file a final C4 report. That is the after campaign or after election report, the post general election C4 report, and that was due no later than December 10th, 2018.
And Ms. Tyler was 2018 candidate for Chelan County Sheriff and did win that. I see from your paperwork that she exceeded the limits for anonymous contributions by $421.
And I'm sorry, like I said, I'm having some technical issues here where I may have missed a word. She was unsuccessful in her campaign. Correct. So yes. And yes, she exceeded the limits by $421.25.
And what is staff's recommended penalty in the matter?
The staff's recommended penalty is a total of $921.25, which fits with the WAC 390 37-143 penalty schedule. And that would be $250 suspended. So it's the amount of that she has needed to escheat to the state, plus a $500 penalty with $250 of that suspended.
And would you explain the recommendation for suspension of half of that 500?
The recommendation of suspension would be that she is not found to have committed any further violations of RCW 17A or WAC 390 within 4 years. She files her post-election C4 report, and she pays the non-suspended portion, which would be $671.25 within 30 days.
Very good. Is there any further information from Ms. Tyler or others that that I should take into account at this point?
No, as noted in the report, Ms. Tyler was in communication with the commission regarding this issue. However, it's been a number of months since we have heard from her, and we have tried to reach out via all the tools that we have available, including she was mailed a copy of all the materials that you see today, and that mail has not been returned. So we believe that she has received it.
She will receive the report of our action.
Yes, I will send the information in all of the same ways that I've attempted to reach her, which would be 2 email addresses, one that does go through that is not returned via phone number that she has provided, and the hard copy in the U.S. Postal Service.
Okay. Well, thank you for the presentation and the documentation that is part of the record. I would, at this point, I am prepared to make my ruling in the matter of PDC case 5483, enforcement action against Jennifer Tyler. I find that the record does support a violation of RCW 4217A 6 and that the penalty will be a total of $921.25, which includes the amount owed in a sheet to the state and a $500 fine with $250 of that suspended, conditioned on no further violations of our WACs and RCWs in the coming years, and that the non-suspended portion of that amount will be due payable within 30 days from the date of the order. And I will ask the executive director to send the final report to Ms. Tyler through means that we are using to communicate with her. Is there anything further go into my remarks, Tabitha or Alice?
I don't have anything to add, Alice.
I think that I have everything I need. If you have any other questions or information you want to have, going forward, Chair Emmons, I would appreciate, or Commissioner Jarrett, I would appreciate it because I may have another one of these coming up.
Thank you very much. Commissioner Jarrett, do you have any questions of what we have just done? I'm having a connection there. Okay, we will proceed, and I hope someone is able to work with Commissioner Jarrett to get or someone could be contacted to help him be connected. This is primary, maybe his only opportunity to be observing this process. Will be doing it himself. Very good.
Dave, this is Tabitha
Yes,
Blacksmith.
Tabitha.
I'm sorry to interrupt. I think Commissioner Jarrett is muted, and I think that we might be able to unmute him, but Tab, that might be you. I don't know if I can do it.
I'm on it. Give me 1 second.
Oh, thank you. I thought he might have something to
I'm
add.
not sure if we can unmute. I'm not sure if we can unmute. We can mute people, but not unmute. *6, I believe, is when you're on the phone, the option for unmuting yourself.
6.
Make a difference?
Yeah,
We can hear you now.
Hear you.
Oh, excellent.
Perfect.
Thank you.
Good.
Can
Good.
you hear me now?
You were in the will. Yes. Can you hear us?
Yes, I've been listening all along.
Oh, excellent. Excellent. Well,
I figured you were just
didn't want
missing
you-
me.
No, we didn't want to leave you in the wilderness. So my question was whether you had any questions of staff or the process that this enforcement matter went through.
Nope, I think following along.
Very good. Well, thank you much, and thanks for being with us today. Appreciate it. So we will move on to the next segment of our agenda, which is group enforcements, candidates, C1s and or F1 reports. And I will ask Tabitha Blacksmith to present at this time an overview of the process we use for group enforcements and what is required of candidates in the state of Washington.
Thank you, Chair Emmons. Today, the Public Disclosure Commission PDC compliance staff are conducting brief adjudicative proceedings, brief enforcement hearings under the Administrative Procedures Act, RCW 34.05, for the following mandatory filer types who were due to file the following reports with the PDC no later than June 1st, 2020. Number 1, 2020 candidates that are required to file a candidate registration or C1 report. 2, 2020 candidates that are required to file a personal financial affairs statement or F1 report disclosing personal financial activities for the previous 12 months. And 3, 2020 candidates that are required to file both the C1 and the F1 reports. Pursuant to RCW 42.17A.205 and .700, all candidates running in state, local, and judicial elections with a jurisdiction of 5,000 or more registered voters are required to submit a candidate registration C1 report and a personal financial affairs statement F1 report within 2 weeks of becoming a candidate and no later than June 1st. Those candidates with a jurisdiction of 2,000 or more, but less than 5,000 registered voters, are only required to file an F1 report. The candidate registration collects information regarding the candidate's office sought, reporting option, campaign officers, and contact information for scheduling a review of the campaign's books of accounts. And the personal financial affairs statement is a conflict of interest statement wherein candidates disclose their income sources, real estate holdings, and other financial activities. The candidates we're hearing today were sent a total of 3 email reminders on May 28th, June 4th, and June 9th of 2020, respectively. Starting on June 15th, 2020, PDC staff also began calling candidates by telephone regarding their missing reports. PDC staff emailed the candidates a warning letter regarding their missing reports on June 17th, 2020, and sent out paper warning letters by mail on July 16th, 2020. On September 22nd, 2020, PDC staff sent out hearing notices both by email and mail, notifying these candidates of their failure to file the C1 report, the F1 report, or both. None of the emails have bounced, so we consider these candidates to have been served. Those candidates that wish to avoid a hearing were instructed to file their missing reports and mail their signed statement of understanding and payments so they are received by the PDC no later than October 15th, 2020. As a courtesy to these candidates, PDC staff have accepted these items up through October 20th, 2020, which was yesterday. If a statement of understanding and payment is received from a candidate after yesterday, October 20th, PDC staff will apply the payment received towards the penalty amount assessed by the commission. Some candidates responded to the hearing notices by submitting their missing reports, signing a statement of understanding, acknowledging their failure to timely file the necessary reports, and submitting $100 per missing report to the PDC staff. In this way, PDC staff were able to resolve 5 of these cases with a statement of understanding, while 2 cases were resolved administratively. Thank you.
Thank you, Tabitha. Appreciate that. The chair would just request that going forward that we close off the submission of those various documents you were talking about from the regulated community earlier than just the day before the hearing. If we could back the way we do with stipulation when the full commission is working is that we like to have it at least 3 days in advance of that if possible, so that we can review the full case file for the particular brief enforcement hearing and not have to try to play catch up right just before the hearing puts extra stress on your presiding officer. So just a friendly request to just back up the cutoff date.
Is that 3 calendar days or 3 business days?
Either is fine. I just,
okay.
We do open our email through the weekend, I think. So however you would like to do that, but I think you're being overly generous in allowing people to comply on the eve of the hearing, and they've had notice for weeks and months of their non-compliance.
Agreed. That's an excellent suggestion. Thank you.
Thank you. Thank you for taking into account that assistant commissioners have a lot on their plates typically, and like to read in that's sent to us, but it becomes difficult right ahead of the meeting. So thank you for your response to that. Would you, for the resolved cases list, there were 5 via statement of understanding and 2 resolved administratively. Would you read the name and case numbers for the record?
Absolutely. So the 5 candidates that resolved the hearing with a statement of understanding are Tyler Grow, PDC case number 76890. Jamie Nichols, PDC case number 76882. Liz Pike, PDC case number 76883. Peter Silliman, PDC case number 76888. Cameron Whitney, PDC case number 76873. And then there were two cases that were resolved administratively, and those were for John Dickinson, PDC case number 76886, and Zach Stover, PDC case number 76892. Thank you.
Very much for going the second mile with our filers, and also I would at this time also commend staff for diligence and reaching out to people when they in a fashion know that beyond what I consider respect, it being that and in that I hope there's wide compliance with and an expectation. And I said I do commend the fact that y'all go the second mile for giving opportunities to rectify it ahead of the hearing. So that's my pat on the back for the day. So now we move into the section of our agenda for candidates participating by telephone or in writing. Involves Bridget Farbola. I could probably butcher your name. PDC case 76872, C1 and F1 reports affected. Would someone present that? Is that you, Tabitha, also?
Yes, I'll be presenting the remaining cases up until the second enforcement case at the end.
You.
And some of the information you provided cut out, so I'll just repeat. This is the case we're hearing now is PDC case number 76872 for Bridget Fonbula. And the reports that are affected are the C1 and F1 report. She is a candidate who sought the office of County Charter Review Commissioner for Clark County. She is a first-time candidate, and as a side note, she did try to withdraw from the candidacy, but she wasn't able to make the deadline set by the elections office. So she was planning to submit a withdrawal of candidacy, but we never received it. And then we received a copy of a statement of understanding and a copy of a payment that she just recently mailed. And that's the copies of that should be in the materials I gave you this morning. Yes. And she basically is participating in writing via those emails. That's the, I've talked to her on the phone once, and then she sent the emails back and forth. But at this point, we have a C1 report, but no F1 report for her. And the statement of understanding and the payment weren't received within the time frame allowed. So we are alleging that Bridget Fonbula violated RCW 4217A.205 and 700 by failing to file or timely file the F1 report and the C1 report. As I mentioned earlier, those were due within 2 weeks of candidacy. In 2020, candidate filing week was May 11th through May 15th. So the C1 and F report were due to be filed no later than June 1st. Let's see here. So the respondent doesn't have any prior violations with the PDC. And you do have the information that she provided about mailing in a late statement of understanding and a payment that we haven't received yet. So my recommendation.
Did not received $200 check from her.
She scanned copies of them and mailed us copies and said she was putting it in the mail, but we haven't physically received them back. And it's
Okay,
past the deadline. So basically what I've recommended is have the penalty amount of $400, and that's based on, let me see, what was that based on? The F1 was failed to be filed by the hearing, so that was $250. And then she did file the C1 report before the hearing, but we haven't received the statement of understanding or the payment in a timely manner. So that would be an additional $150, which brings us to $400. And I don't have any recommendations for suspension, but I did want you to know about her extenuating circumstances in the event that you wish to modify the amount. And I'm done. Thank you.
I would like to modify it to suspend $250 of the total amount based on her attempts to comply for the hearing. She is showing good faith, as I can tell from reading the record. Would be 250 off 400, so that would be the final amount with $250 with 250 suspended, let's say that way, and then conditions of our in the next 4 years, and the payment of the non-suspended portion to be received within 30 days after receipt or after the issuance of the final report.
Commissioner Ammons, I do still need an F1 report from her. Should I put that in the order as well? And is there a deadline?
What would be appropriate deadline?
Well, it was due a while ago.
I understand,
I
but now we're sort of trying to bring it all to an end conclusion here in a way that understands she's having difficulty complying and yet seems to show evidence that she's willing to work with us. So
maybe 30
would that
days.
be another 30-day timeline there? I'm fine with that, and that she will submit her missing F1 within a 30-day period, within receipt of the executive director's final order.
Thank you. Excellent.
Thank you. I appreciate that. And the circumstances are a little bit different for each individual, and we try to take that into account. The next case is Sandy Messenbrink.
The next case before us, as you said, is Sandy Messenbrink, PDC case number 76886. The reports filed that are affected, are the C1 and the F1 report. Sandy is participating in writing, and I did provide you with those materials this morning. Pardon me, I'm having trouble getting to that. And I did respond because some of the information in Sandy's response was factually incorrect. So I provided Sandy with some additional information where things could be found in the hearing notice. Sandy basically provided a check in the amount of $200, but we have not received, let's see here, my apologies. We've received the reports, but we have not received the SOU, the signed statement of understanding, and the payment had to be returned because, because of the black ink on there. If you can see that it bled through the check, so we weren't able to cash that. And Sandy just had sent a letter that that they thought they had mailed the documents previously, We don't accept those filings by mail, so it's possible they did mail them and it got sent back. Those are required to be filed electronically unless they apply for a hardship exemption. And so we did get them, but it was after the hearing notice. And I should also mention that Sandy is a first-time candidate. Let's see what else we have here. And no prior violations for Sandy. So first-time candidate, no prior violations, and did respond with that cover letter and attempt to make a payment. So for Sandy, I've recommended I have also recommended a $400 penalty amount for, pardon me. We're recommending that you find a violation of RCW 4217A 700 and 205 for failure to file or timely file the missing reports, and assess a penalty in accordance with WAC 390-37143. And I arrived at the amount for this, just like the last one. We did get the report before the hearing, but we didn't receive the statement of understanding, or and then the payment we weren't able to accept that either. So because they didn't file the statement of understanding, I based that amount, let's see here. I think I arrived at that actually by, it was 150, filed the report before the hearing notice, after hearing notice, but before the hearing. It did not enter into a statement of understanding because I'm not able to accept what they submitted for payment, and there was no statement of understanding. And then the other report was received, and that would have been $100 because it can be 0 to 150. So that's how I arrived at $400. And again, if you want to suspend some, I'm happy to hear what you think.
So say more about the statement of understanding. Did she make any attempt to comply with that requirement?
No, we just got the letter and the check. So the letter was kind of the written response, and then there was the check that we had to send back, but we didn't get the statement of understanding at all. So we would have needed that by yesterday in order to apply it.
Check.
But
doesn't bother me because she's attempting to submit in usable form, I'm quite sure.
Yeah.
The statement of understanding, which would have gotten her off the hook more, should have been done. Was she aware of the significance of the statement of understanding?
I believe so. There was extensive information about it in the hearing notice that we mailed and emailed to the candidates. I don't believe I had any interaction with Sandy. I did, let me see. I did, of course, send a response to the letter letting Sandy know where that information could be found, but we haven't specifically discussed why the statement of understanding didn't come in. I just found out about this yesterday, and there was a lot of incoming mail yesterday, and I haven't had a chance to speak with Sandy by phone or anything.
Mm-hmm.
But I think that was maybe a good faith attempt, which is why I put it at $400. But again, it's up to you.
Well, I think I will treat this much as I did in the last one. I will find a violation of Sandy Messerving, case number, let me find it, 76886, for C1 and to submit a thing that will find, but also showing some attempts to comply with our reporting requirements. I believe she submitted it. Good fit, presuming that would take care of what she's believed to be owing. So I'm ready to rule there to that effect, and also to accept recommendation for $400, but with 250 of that suspended. Reasons I've articulated, and that would be on no further violations in the next 4 years, and that the non-suspended 150 within 30 days. And let's see, does she still need to do a statement of understanding, or does this resolve her case?
No statement of understanding, Commissioner. The penalty you're assessing would replace that.
Thank you. So that will be my ruling, and we will issue the executive director will issue the final order within 30 days, and then her payment will flow after that.
Thank you.
Okay, we have the next one is a gentleman who would like telephoned into the meeting, Daniel Miller.
Yes, sorry, I'm having some technical difficulties. Bear with me 1 second.
Thank you.
Uh-huh. Okay. Sorry, it's lagging on calling. Do you want to move to the next one while I try to connect him?
That would be fine. That would be fine. We would do C1 reports with Razi, case number 76884. Candidate with no prior violation who signed statement of understanding but failed to file C1 report before the hearing. Staff would present.
Thank you, Commissioner.
You're muted, Tab.
My apologies. Thank you. As you stated, this is PDC case number 76884 against William Razi, who was a candidate for state representative for Legislative District 14 House. William is a first-time candidate in 2020. And he has he submitted a statement of understanding and did make the payment, but did not return the C1 report, which is still needed. So I have recommended, pardon me, we had a late one arrive here. I've recommended, let's see. Oh.
Excuse me, we've got Daniel coming in. Hello, this is Fox Blackhorn. You're on.
Back with you as soon as possible. Thank you.
Mailbox is full and cannot accept any messages at this time. Goodbye.
Okay. We can try that in a few minutes.
Yeah, that happened to me when I tried to reach Mr. Miller yesterday. And I got a voicemail box that was full, and he had asked for a time after 10:30 when he would be on a break. And so that's why we pushed him out to this time. And unfortunately, it sounds like he's not answering. But how would you like us to proceed with Mr. Miller? Just come back to him?
Yeah.
Okay.
Yes. This one we're in the middle of.
So I'm back with Mr. Razi's case, and We did even email him a reminder to file the C1 on October 8th, but we have not received it. So I am recommending, per the penalty schedule, WAC 390-37143, for a candidate who has not submitted a C1 report by the date of the hearing. I'm recommending $250 penalty. And because he did submit the statement of understanding, I wanted to ask to have 100 of that suspended because he's already paid $100 with that statement of understanding.
Does this seem like similar treatment that others with this fact pattern have shown?
We have in cases applied money that we had received to a penalty. We want to make sure that's okay with you, but we have done things like that in the past.
So if he had not filed an a statement of understanding, it would have been $250 for not submitting the F1.
Correct.
And because he signed the MOU and the 100, you're saying you would reflect that 100 by subtracting it from the 250.
Correct. I wanted to give him credit for his good faith attempt to solve.
Absolutely. Well, I'm prepared to rule at this time. I do find that Mr. Razzie did violate RCW 217A. What was the numeral after 17A?
0.205 for a C1.
205. And at this point, I will assess the standard penalty of $250 for that violation, and we'll suspend 100 of that for the amount that he has already, has already submitted along with his statement of understanding. And so he will still be owing $150 to resolve this matter. And I don't think I will put any further strings on that. There will be that will be due within 30 days of the final order.
Commissioner, and the C1 report also due within 30 days as a condition?
Yeah.
Okay.
Yes. And yeah. Mm-hmm.
Thank you.
Thank you. Okay. That completes that one. Do we want to try Daniel Miller again?
Certainly, yes. And I'm just following along with the hearing as well. What was the penalty that was assessed in that last case?
It was $250 with 100 of that reduced by 100. So 150 is the final bottom line.
Okay. Got it. Thank you so much. So are we applying, if there is 150 due, I know that there was discussion about applying this previous payment. So if we apply it, there would be $50 still due and payable. Is that your intent?
The recommendation was for $250 as the penalty, and then that to be reduced by 100 because he already submitted $100 already with the statement of understanding. So the bottom line is he still owes PDC $150.
So then you would like us to return the check for $100 and then issue an invoice saying there's 250, but you only owe 150 of it? Is that correct?
Well, I don't know how you do your ending, but he just owes another. I think we've probably already processed 100, and that he still needs to send a check for $150 to complete his penalty.
And so then with future compliance, the penalty for failing to file this will actually be a total of $350?
No, I'm not adding this spending the um, that amount and applying conditions to that as we often do when we do suspensions. I'm simply reducing the penalty by the $100 to reflect the fact that he's already paid that much as part of the process. If that's clear.
So then, I'm sorry, but if we are accepting $100 and he pays another $150 within 30 days of the date of the order, that's $250. Let's
Correct.
say hypothetically in next year there's an additional violation, then there's an additional $100 that's owed for a total of $350. Is that your intent?
No, next year will be a whole new thing. If he runs again, that would be another proceeding.
But that would trigger the suspended penalty. And so then there would be $350.
I guess perhaps suspension is the wrong word to use for the $100 reduction in the recommended amount. I'm lowering I'm amending staff recommendation for $250 by 100 and by 100. So still owing per this order is 150, and we've already taken his or the letter of understanding. Correct, Tabitha? You're nodding your head. Yes.
Yes, and I think part of the issue here is that the penalty schedule doesn't really reflect what to do if, they've got failure to file a report by a certain day, and they've got a different one if you participate and or have mitigating circumstances. But all of those other ones talk about not submitting a statement of understanding, and he did try to do that. And then all I had left to go with was the failed to file the report by the date of the hearing, which was the $250 because it's the first time violation. That's how I came up with $250. But I can put in the order instead of suspension. If it would help, I could just use your reduced by the payment, already made in the amount of whatever. Yeah. Would that help? Do you think?
That's my intent. Sure.
Okay. So then if I may clarify, are you intending to assess a penalty of $250 to accept the previously tendered payment of $100 so that the remaining balance is $150?
Correct.
Wonderful. Thank you.
Thank you.
Thank you. So let's try Daniel Miller one more time.
Okay, dialing now.
Hello, thanks for calling.
Daniel?
You as soon as possible. Thank you.
The mailbox is full and cannot accept any messages at this time. Goodbye.
All right.
Did he have a good phone in number?
That's the number he gave me.
No, for us. For him to call in to us. Does he have that number as far as you know?
I don't think we do that. I don't think there is a call-in number. We usually call people.
I can provide that via email. Normally what we do is we reach out to them with the number that they give us. I can definitely send a message now and send that phone number if you would like to hold over this particular matter for a little bit longer.
That's fine. And we may, if he say he wanted to be heard, we can even hold it over to another VAP hearing. So let's with that one, and then we are up to the 11 o'clock slot on the candidate with no prior violations who has filed C1 report and signed statement of understanding before the hearing, but failed to include payment. This is Jess, yes?
Sorry to continue to interject. We do have another phone participant that asked to participate at the last minute, so we weren't able to update the agenda. Would you like to continue with the agenda or address the other phone participant before moving on?
Yeah, I didn't have that on my agenda. So which person is this?
Constable, she contacted us this morning and indicated a desire to participate by phone.
Okay,
She's
then that's
number 12 on your list.
I can see it under the 11:30 a.m. docket. So that would be fine if you would like to try to reach her and
All
take
right.
that out of order.
Dialing now.
Thank you, Fox.
Of course. Trying to dial, but I'm not hearing a dial tone.
We're not doing very well with the old technology today. Rather than the whole, why don't you continue trying to reach her, and we will interrupt if whatever we're on with to go to her case. So let's see. So back to Jess Mahan, right? He's 6875.
Correct. Would you like me to proceed, Commissioner?
I would, yes.
As you mentioned, this is PDC case number 76875 against Jess Mahan. Jess was a candidate for County Charter Review Commissioner for Clark County and is a first-time candidate in 2020. Let's see here. We are alleging that Jess Mahan violated RCW 42.17A .700, well, excuse me, 205 and 700 for failure to file or timely file the personal financial affairs statement, F1 report, and the candidate registration, PDC form number C1. These were both due to be filed with the PDC within 2 weeks of declaring candidacy, and that would have been no later than June 1st. Jess has filed after the date of the hearing notice, but before the hearing did file a C1 report. Pardon me, I need to make a correction. The F1 report was not due. And excuse me, I have a spreadsheet that doesn't line up here, but has filed the C1 report. So that would just be a violation of 205, and did sign a statement of understanding, but didn't include the payment. So we weren't able to process that. So received the statement of understanding, but no payment. The report was filed by the date of the hearing. So I have suggested a recommended penalty amount of $150 for someone who files the report before the hearing but doesn't enter into a statement of understanding. And like the other one, my recommendation is to, well, I was going to suggest maybe suspending 50 of that and allowing them the chance to submit the payment that was missing within X number of days. If that's not submitted, then that person would actually owe $150. And I wasn't sure how you felt about reducing that amount pending this payment coming in, but that was my suggestion.
What's the payment coming in you would expect?
It would have been $100. So I was suggesting normally it would be $150, but if we allow them to send in the $100, then we would maybe want to suspend 50, or we could leave it at $150 and apply the $100. I'm not sure how you want to handle it. I have a lot of odd ones this time that don't quite match up to the penalty schedule. So I'm happy to be a little creative and then just give you the information and see what you think.
So what are we missing from him?
We've got the report. So the only thing missing is the, what did I say? Just the payment that would have gone with the statement of understanding. If we had gotten that, they wouldn't have had to come to hearing. But again, it just came in yesterday without the payment. And so we weren't sure how you want to proceed with that. But normally the penalty without an SOU would be $150 for filing before the hearing.
Mm.
And I promise that's
So,
the last unique one.
are you expecting, would you be anticipating getting $100 check from him?
Well, the Mahan has made a good faith effort to comply by filing the report. I don't have any reason, and submitting the SOU, I don't have any reason to think they wouldn't submit a payment. I just haven't had a chance to reach out yet to let them know that there was no payment included and that we still need it, and then provide a deadline by which that needs to be here.
Well, so it would be 100 for that process, or 150 for the chart that we have, the standard. So what, I guess I'm wondering where the $50 reduction comes into play.
I recommended suspending 50 to bring it down to 100, which was missing from the statement of understanding packet. And again, it's only if you wanted to do that. I think
so it would be dollars either way. Either it comes in to the MOU process or as a penalty, standard penalty.
Correct. I think at this point we have to go through an order. So that's why I mentioned it, but you know, I'm equally happy with the 150. It's up to you.
Well, I think I will follow staff recommendation and find a violation of by Jess Mahan 76875 is the case number for failure to file an F1 in timely fashion. And
excuse me,
yes.
Commissioner Evans, it's a C1 report, so it would be a
C1.
violation of
Thank
205.
You. 205. Yeah. Thank you. Thank you.
Thank you.
And I will assess a penalty of $100 to Mr.
Mahan, I think.
Yeah, Mahan. Yeah, sorry. Yeah. I'm jumping back and forth between charts and
Yeah.
agenda, and it's kind of weird. But yeah, I'm gonna do that, and then that will be seems like it's about $100. If he had paid $100, it would have gone away, and he has that's still been in process. So I'm thinking whether we do 150 and reduce it by 50, it's still 100. So the staff a recommendation, which is gives you a little bit of guidance for future cases that are like this one, how you would like to, what best practice might be on this.
It sounds to me like you're recommending that the penalty amount be reduced the amount we want to assess instead of calling it a suspending a portion. We would just recommend 100 next time.
Yes,
Oh,
that's my what
Okay.
I wanted to do, but before I pound the gavel, I wanted to make sure that makes sense to staff who live with this stuff all the time. So that's what I will order as the penalty is $100, and a final order will be issued by the executive director within 30 days.
Thank you.
And let's see, do we need to put in a 30-day timeline for submitting the missing C1?
We received the C1. We already received the C1. And this, like I said, the statement of understanding, but no fee. So I don't need any reports, but we would need
Okay.
the payment by 30 days, it sounds like.
Yes.
Oh, thank you.
Thank you. Thank you.
And Chair Ammons, we have Megan Constable on the line.
Very good. Megan?
Yes.
Hi, this is David Ammons, Chair and Presiding Officer at this enforcement hearing today. And we're going to ask staff to brief me, and also Commissioner Fred Jarrett is also observing this process today, and he is on the line as well. And so we're going to be briefed on this matter. I've received paperwork in advance, so I have some knowledge of it already, but we will have a briefing right now, and if you would like to be heard, which I presume you do, I will swear you in at that point so that you may be heard.
Thank you.
Would you like me to take it away, Commissioner?
I would, please take it away.
So this is PDC case number 76880 against Megan Constable. Megan was a candidate for County Charter Review Commissioner in San Juan County and a first-time candidate in 2020. Flipping my page here. Megan has not filed the C1 or the F1 report, has not submitted a statement of understanding. So our recommendation was the penalty amount per our penalty schedule, which would be $250 per report for failure to file by the date of the enforcement hearings, for a total of $500.
Thank you.
That's my recommendation. Thank you.
Thank you. And Ms. Constable, would you, if you'd like to be heard, would you raise your right hand wherever you are and be sworn in? Do you swear or affirm that the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. She does. So you have, I'm all ears.
Okay, so it was my understanding before being convinced by friends and neighbors to throw my hat in the ring that I did not have to file a C1 or an F1 because in reading RCW 42.17a.200, the exemption states that for a precinct committee officer, which I am the precinct committee officer for Lopez South, that it is in the same manner that the Charter Review Committee functions, that I represent 1,534 voters on Lopez. And I'm also a volunteer EMT, so I know some of those have left us already. And they are deceased. And I also represent Shaw Island, as far as my understanding goes. And my parents live there, and there are 150 full-time residents. And not all of them are registered to vote. So per the reading of the RCW, it was our understanding as a group that it is fewer than 5,000 registered voters. And even going to RCW 42.17a.135, 2 through 5 and 7 states that if you're representing just a subdivision with fewer than 2,000 registered voters as of the date of the most recent general election in the jurisdiction, that you are exempt. So I'm either completely misunderstanding the rules that we all talked about before deciding to throw my hat in the ring, as I stated. I thought, I'm a firstborn rule follower, so I very much thought that I was following the rules, and was waiting for the hearing to state that this was my understanding, that I was correct, that I did not need to file a C1 or an F1 because I'm representing, just like a precinct committee officer, I'm representing a small group, and I, just like the precinct committee officer, then we do meet together, but it isn't, I have nothing to do with the other islands. I'm just bringing the information to people in my circle and it's a non-partisan office, so it's just representing my neighbors. And no money involved. It's a volunteer situation. I have no campaign money funding. I've done no advertising of any kind. Like, it's just totally a volunteer thing. So, aware until receiving the letter, and then last night at about 1:30 in the morning, going through mail for the amended paperwork. And I'm behind on opening my mail because we just found out my dad has hairy cell leukemia. So we've been working together on that as a family. So I'm just behind on my mail. So that's it. I had no intention of breaking the rules. I thought I was within the rules as I read them.
Are you still a member of the commission, the review commission?
I've never been. It's my first time. I've not.
You are currently running for that position of Charter Review Commission. Okay, thank you. Staff, would you reply? And it seems like there must have been a steady stream of communication about the fact that this was a position that those documents to be filed. I am aware from previous work on the Public Disclosure Commission that that charter review commissions are explicitly included in the offices for which state public disclosure is required. But I'm wondering the level of communicating with Ms. Constable, and whether that was communicated to her that indeed those reports are required, that it's covered, et cetera. Could you describe that a little bit?
Yes, Commissioner Ammons, this is Tabitha Blacksmith. I only found out about this Megan's understanding of the rules today. Hasn't been a prior discussion, but we did ask Sean Flynn, our attorney, for some help with this, and he looked it up and he basically told us that RCW 4217A.135 does exclude subdivisions, but the subdivision is the county, not the district. So it doesn't exempt review board positions. And then RCW 4217A.200 refers to the office of a political subdivision that is not countywide and under 5,000. So I think it's just a misunderstanding, good faith misunderstanding of the requirement. But no, we haven't had a chance to discuss it until now. But what Sean indicated is that each election district is not a political subdivision based on the context of that.
Okay, I'm going to find that there has been a violation of RCW 4217A, and what's the numerals after that?
0.205 and 0.700.
0.205 and 700. I'm further going to and the standard penalty for that is $500. I'm going to, in abundance of compassion, suspend all of that, conditioned on submitting those necessary reports within 30 days of receiving of the final report from the executive director going out to her. It is a requirement of service. And I'm sorry that you did not hear or understand that as part of the obligation of a candidate for this particular position. I take at face value your understanding that it was not required, but it is. And so if you get that in a timely fashion, there will be no additional penalty.
Okay, I'm very grateful for that. I have one question about the F1. Our children are all adopted, and two of our children, their birth mom is still living, and she lives in the state of Arizona, and that's where we adopted our children, and she's a rather corrupt person. She has very close ties to the second most powerful drug cartel in Mexico. So we're very private about our information. And so because I haven't done anything with F1 or C1, but F1 I understand is financial, and it gives like more information. I'm just wondering how does that work if somebody were to Google Scott and Megan Constable? Like, does that then pop up immediately for her use and abuse?
It is a public record. I don't know if it would pop up on a search. There are it is possible to ask for a safety exemption. It would be a modification request of the full commission. But other than that, I'm wondering if staff would someone on staff would call her offline and discuss the F1 process with her and what's required, and she can in the meanwhile quickly call up the form online, pdc.wa.gov, and see what's required there. And
I think I've been sent a website to that has a training. I think
Okay.
that there is a click, I think in the emailed version of the letter that I received September 22nd, so the amended version, I received a letter. Oh, there was one written the 21st and then the 22nd. So those are the two communications that I received, but also an email version. So I think that there's a live link that I can click on that talks about how to. So I don't
Okay.
want to take anybody's extra time in this.
No,
very busy time
but
to
I would
reflect.
hope you can comply fully with that and submit it in full. I've really bent over backwards to suspend $500, and this is a requirement of all people who are running for any level of public office, from the tiniest burg to the governor of Washington. And it's out there. It isn't accessed a whole lot. It just between you and me. So I think probably any hazard or safety concerns would not arise from F1 disclosure in the state of Washington. There are many ways to get at identifiable information, as you probably know, on the web, on the internet, on search engines of various kinds. I don't think we would rank very high on that search list myself.
I hope not. And I do appreciate the chance for me to comply without a fee. I really appreciate that. And
You're sure welcome. And call or email staff if you have any difficulties filling that out or have any further questions. We aim for people to be successful in filling out their forms, making it as painless as possible, while the people voted 50 years ago that this was going to be a requirement for anyone running for public office at any level, local or state. And it is a value, as probably is your value too, for sunshine and transparency and for basic information about the people that we're voting on.
Yes, I agree, and I do honor and respect transparency. Totally. I like an open book policy, and I'm the treasurer for our EMT association, and we have an open book. Come look anytime. So
Very good. Well, I appreciate that attitude. And Tabitha, did you have anything further?
Yes. Did you see me moving my lips? So the reason I wanted to ask you for the order, if she does get an F1 reporting modification, it's going to probably take more than 30 days to get through that process to file the F1. Well, I guess the F1 would need to be filed first. I'm not sure if we want to put that in the order, or is that just something we'll figure out on the side? Because we can have her file for F1 and then just check that she's getting a reporting mod. So we may not get everything, but we can work with her. I'm happy to do it.
I think that would be fine to handle it offline that way. Where I'm hoping that she can be in full compliance, so that it doesn't have to go through the mod request. I'm not sure. Those are pretty. It has to be the only modifications that we can that are permitted by the commission to approve are those where there is an actual showing of an actual threat, and usually these are for sheriffs and have been for law enforcement and others who are in harm's way. So typically we are pretty parsimonious with doing modification requests for on-address confidentiality. So I just want to be upfront with that piece. So any further questions?
I'm good. I believe
Very good.
walk my way through and contact. I believe is it Tabitha. If I have questions or can
Yes.
help, and it's a good education process.
Well, yeah, and welcome to politics and public service. It's it does have some things to consider. And sorry if it was a big surprise for you, but it definitely is covered. So thank you, and we will conclude this portion of our hearing.
Thank you.
Yep. Okay, now back to, are we good? I guess we didn't reach Daniel Miller. We're back to the 1105 series of people, right?
Correct. These are all a batch, so we can probably move them through them pretty quickly.
Very good. Why don't you proceed?
Okay. All right. So this is these are PDC cases number 76879 for Matthew Murray, 76887 for Stephen Sharon, 74524 for Jody Wilkie, and 76891 for Gary Ray. These are candidates that are seeking, let's see, the following offices here. Pardon me, I have some flipping to do. So Matthew Murray was a candidate for governor of the state of Washington. Stephen Sharon was a candidate for public lands commissioner, state of Washington. Jody Wilkie was a candidate for state representative, legislative district 24 House. And Gary Ray was a candidate for county commissioner, Island County. Matthew Murray is a first-time candidate. Stephen Sharon was a candidate in 2012. That was the last time before this year. Jody Wilkie was also a prior candidate in 2018, and Gary Ray was a candidate in 2016. And all these aforementioned individuals have not filed the following reports. It would be the C1 report and the F1 report. So I am alleging that they have all violated RCW 4217A.205 and .700 by failing to file the F1 report and the C1 report that were due within 2 weeks of candidacy or no later than June 1st. And for this batch of folks, I'm recommending the penalty schedule set by WAC 390-37143, which is, pardon me, actually, I apologize, those are all, I need to backtrack. We're alleging a violation of RCW 17A.205.
Which is F1s only.
Oh, no, it's F1s only, you're correct, that's 700, so I need to amend what I was saying. And that's why we're recommending a penalty of only $250, which is the penalty amount for a first-time violation and failure to file the report by the date of the hearing.
Thank you.
Would you like
Thank
me
you.
to
I
repeat
appreciate
anything?
No,
We're good.
that's fine. I'm ready to rule. Having considered all the evidence presented, I do find that Matthew Murray, Stephen Sharon, Jody Wilkie, and Gary Ray, and their cases are respectively 76,879, 76,887, 74,524, and 76,891 for violation of RCW 4217A.205. And I will assess the recommended penalty from the penalty schedule of $250 payable within 30 days is our usual order. And is there anything further on those matters?
Yes, the missing F1 report also within 30 days for the order?
Yes.
Okay. Thank you. No violations for 4 years?
I don't, do we normally do that for when there's no suspended portion?
Oh, you're right. Never mind. Thank you.
Okay,
Okay.
thank you. Thank you. And let's see,
Another
there is one that includes both C1s and F1s, which might have confused you, because there is a person like that called Kelsey Reyes, case 76877, no prior violations. Excuse me, I actually misstated that. Did file F1 and C1 reports before the hearing, but did not a signed statement of understanding. So could you talk about that?
Absolutely. So as you mentioned, this is PDC case number 76877 against Kelsey Reyes, who was a candidate for Public Lands Commissioner in Washington State and a first-time candidate in 2020. We are alleging that Kelsey Reyes violated RCW 4217A.205 and .700 for failure to timely file the F1 report and the C1 report, which were received after the hearing notice, but before the hearing. And those were due within 2 weeks of candidacy or by June 1st. Now, those have since been filed, so the recommended penalty amount is going to be $300 per WAC 390-37143, which is the commission's penalty schedule. And that amount is for filing the report after the hearing notice, but before the enforcement hearing without a statement of understanding. So it's $150 per report for total $300. Thank you.
The reports have been received before the hearing. And so we're talking about the lack of a statement of understanding. Is that mandatory?
No, what happens is there's a different penalty amount if you've returned a statement of understanding, but if you don't enter into one, but you submit the reports late, then it's $150 per report.
Gotcha.
Yes.
Gotcha. That is clear now. So in the case of Kelsey Reyes, PDC case number 76877, I will find a violation of RCW 4217A. And what's the rule on that?
.205 and .700 for the C1 and the F1.
Even those of received, I find a violation of that.
Okay. 205 and 700.
Is that still what my motion should be? That I find a violation even though those have been submitted?
They were late filed.
Late file.
So the violation is late filing.
Good. And I will order a penalty of $100 for that violation, for those violations, to be paid within 30 days. And you still need a signed statement of understanding, or does the penalty reflect close the matter?
No statement of understanding at this point. It would just be the penalty. And to be clear, you're not suspending anything. You're just setting a penalty amount of 100.
Yeah.
Okay. And due within 30 days.
Okay. Right.
Thank you.
Okay, now we have 3 persons who were candidates with no prior violations who failed to file C1s and F1s before the hearing and failed to sign statement of understanding. Would you tell us about those three individuals?
So this is PDC cases number 76889 against Thor Amundsen, 76881 against Michelle Jasmer, and 76885 against Robert Redwine. These individuals were seeking, Thor Amundsen was seeking, it was a candidate for governor, state of Washington. Michelle Jasmer was a candidate for lieutenant governor. Robert Redwine is a candidate for state representative, legislative district 37 House. They are all first-time candidates this year. And we are alleging that they violated RCW 4217A .205 and .700 for failure to file the personal financial affairs statement and candidate registration that were due within 2 weeks of candidacy or no later than June 1st. And as of today, I don't believe we received any of those reports. Let me double check here. Yeah, the reports have not been received and they did not enter into a statement of understanding. So we are recommending, per the penalty schedule, $250 per report that has not been filed for a first-time candidate. So that'd be a total of $500 for the 2 reports. Thank you.
Thank you. And have we heard back from any of those 3?
The only individual that communicated with us was Thor Amundsen, and we had sent an email to his Gmail account of record, and he wrote back from another Gmail account, which was almost the same, but it had a dot in it, and said, please use this email. So he did get the notice by email, but wrote back asking us to use a different email address, which we did. And I emailed him to say that I updated it, but I never heard back after that. So there was just the one email.
So you believe he is aware of the requirement to file those 2 missing reports?
I do, for a couple of reasons. One, he responded back, and 2, I did a little research and I found out Gmail, when you own a Gmail account, you own every variation of that email, whether you have dots in between parts of the name or no dots, it doesn't matter. You will get that email and no one else can have an account with any variation of that. That belongs to you. So, and I know from personal experience as well, I have 2 Gmail accounts and the dot doesn't matter. So he would still be getting the emails, I believe, but we went ahead and updated it for him because he asked us to.
That's good to know.
Yes.
Okay, well, I again appreciate the numerous efforts to reach these folks on different platforms, and that I will find that in each of these cases, Thor Amundsen, Michelle Jasmer, and Robert Redwine, cases respectively 76889, 76881, and 76885, that they are each in violation of RCW 7217A .205 and .700 for failure to file C1 and F1 reports before the hearing, and who did not have a signed statement of understanding on file. Those orders will be issued by the executive director within 30 days, with the penalties of $500 in each case, to be paid within 30 days. And I think that is all for those folks.
Commissioner, the missing reports also due within 30 days?
Sure.
Thank you.
Okay, we're coming down to our 11:50 docketed matter. Dana Kinsey. Could you tell us about Dana?
Yes, absolutely. So this is PDC case number 76878 against Dana Kinsey. Dana was a candidate for County Charter Review Commissioner in San Juan County, and was last time was a candidate in 2015. And staff is alleging that Dana Kinsey violated RCW 4217A.205 and .700 for failure to timely file the C1 and the F1 reports. And they have since been received, but they were late filed. And they were due within 2 weeks of candidacy, but no later than June 1st of this year. And there's one prior violation for Dana Kinsey, and that was PDC case number 22114, which was resolved via a statement of understanding. So for that reason, I set the recommended penalty amount at $600, which is $300 per late report for a person with a second violation. So if you find a violation, this will be the second one. Thank you.
So that's why it's not 500.
Correct.
And we have the filings, but that's required even though we have received those. The penalty schedule says there is that if they violated that is at the level of 500, and a second violation for Dana Kinsey would make that 600.
Correct. Unless you suspend some of it, it would be $300 per report.
It sounds to me that that particular Charter Review Commission has not given its candidates proper information about the requirement to file. And I would suggest that somebody on staff try to find a person who's staffing that commission and remind them. And if we can figure out a way to publicize the fact that this is an office that requires timely submission of those reports. It sounds like some bad information is circulating up there in San Juan County. Would appreciate that little extra bit of outreach to them. I'm going to find that Dana Kinsey is in violation of RCW 4217A .205 and .700 for late filed C1s and F1 reports with no statement of understanding. And so pursuant to the penalty schedule for both late reports, missing and late reports, C1 and F1, and also because it is a second violation, that a penalty of $600 will be assessed. And the order will be issued by the director within 30 days with a requirement to pay the penalty amount of $600 within 30 days.
Okay. Thank you.
Good. Does that complete your section of the agenda, Tabitha?
It does. Thank you, Commissioner.
Well done. Well done.
Chair Emmons, Tabitha, would you like to try calling Daniel Miller again, or hold that over to a future?
Why don't you give it one more shot and
Dialing now. thinking about it.
Hello.
Hello, is this Daniel Miller?
This is Daniel Miller.
Oh, hello. You are on in the commission hearing. So, yes, take it away, Chair Ammons.
Hi, this is David Ammons. I'm chair and presiding officer at this enforcement hearing. And we did try to reach you earlier, but we're getting a full voice mailbox, so we weren't able to get through to you. So we're happy to have you with us now. I'm going to ask you to be sworn in so that you can make comments to us. And if you would raise your right hand wherever you are, and do you solemnly swear or affirm that the testimony you'll give is the truth, the whole truth, and nothing but the truth?
Yes,
Thank you, Daniel. So at this point, I'm going to ask staff to explain this matter. We do have the written record as well already, but I'd like to recap what the commission staff is alleging. Tabitha.
Okay.
Thank you. So this is PDC case number 76874 against Daniel Miller, who is a candidate seeking the office of county council member in San Juan County. Daniel was a candidate in 2019 as well as this year. And we are alleging that Mr. Miller violated RCW 4217A.205 and .700 for failure to timely file the personal financial affairs statement and candidate registration, also known as the F1 and C1 report. Those were received from Mr. Miller before the hearing, but he chose not to enter into a signed statement of understanding and did submit, let me get to it. There was a payment of $200, but we received that and not the statement of understanding. So with Mr. Miller's permission, I haven't had a chance to talk to him about this yet. We may be able to apply that towards any penalty owed, but we can't hold the check for very long. So maybe he can tell us today if that would be acceptable once you've ruled. But we did get a $200, but not a statement of understanding. So the recommended penalty amount per the penalty schedule, WAC 390-37-143 for a candidate that filed the report after the hearing notice, but before the enforcement hearing, but did not enter into a statement of understanding, is $150 per report for a first-time violation, which is $100, and that's staff's recommendation. Thank you.
And he has submitted, what did you say?
$200. We haven't deposited the check yet because we didn't have a statement of understanding to go with it.
Gotcha.
So, yeah.
Okay, Mr. Miller, this is your opportunity to provide anything you would like to say.
Okay, I have to go pretty soon, but so basically, I believe originally I did file my paper work in hard copy, and I think it was sent back because they want everything to be on the on the website. I did. I'm pretty sure that I had started the process early on of filling out the forms, C1 and F1, I think it's called. And I don't know what happened. I think I thought I had sent it, but I didn't. So I do have a record that I had started on the website. First of all, I'm not accompanied by an attorney, so it's best to be accompanied by an attorney. But so I did attempt to send it in, I believe the paperwork, but I believe it was sent back. And then I did attempt to start the filing on the SAW. I did pay the fine, which is, so they did fine me and I did pay the fine. I did also complete it on the SAW. I completed the forms, so those are complete. And I hope I filed mini. It was a mini reporting. So I did pay the fine. As far as the statement of understanding, that's a whole can of worms, and it just says, do you agree? Do you understand? Well, I don't understand or agree. I don't see how you can be forced to sign the paperwork. So I guess, maybe I will do it under duress, but yeah, I paid the fine. And so, like I told someone else, this isn't Nazi Germany. I can't be forced to sign the paperwork unless I sign under duress. And my $3,200 class is on right now. So I was on the lunch break, but I need to get back to class. But so basically the fine was paid. I also finished the paperwork.
Okay, thank you. Tab, do you have anything to respond to? If we would dispose of this with the penalty, he's not expected to do any statement of understanding, correct? Because that would take the place of that process.
Correct. The statement of understanding is a courtesy to allow somebody to avoid hearing. If they don't want to go to hearing, they can sign a statement of understanding and pay that $200. The issue becomes when you don't sign that and you end up going to hearing, the penalty amounts are a little bit higher. Not significantly so, but then they bump up to $150 per late filed report. So, and it sounds like Mr. Miller would be okay with us applying the $200 towards any penalty. So I leave that up to you to decide what amount you would like to assess or suspend.
Well, I can hear to comply with the reporting requirements for public office in Washington, which the voters approved almost 50 years ago for transparency and accountability in government and people who are running for office and holding office. So I will find that there is a violation of RCW 4217A 2.205 and 0.700, and that the documents have been submitted after the deadlines. I see that the standard penalty would be $300. I would reduce what's still owing to $100 to make allowance for the fact that he has already paid $200 through the statement of understanding process, whether he signed anything or not. I think that was his intent, was to try to resolve it. So I would assess a penalty of $100 and that be paid within 30 days, and from the date the executive director will send the report for the final order. Is there any question, Tabitha?
Mr. Miller, are you still on the line?
Mm-hmm.
Okay. Can you kindly reply to my email and just affirm that it's okay to cash your check? We were holding on to it for a day while we got this straightened out. But if if you would like to apply that towards the amount owed, we can do that. It's just that we need your permission. If you wouldn't mind signing us maybe a little email.
Yeah, otherwise you could sign that. Go ahead.
Oh, I was going to say, otherwise we have to return it to you. And I didn't want to, I felt like that wasn't good customer service, returning your check and then asking for money again. So we can apply that
Right.
towards it if that's okay with you. And I can send you an email.
Right. That's
okay.
right.
He
That was
just said yes.
the payment.
Thank you.
Thank you, Mr. Miller, and thank you for calling in. And good luck with your class.
Okay, I'll talk to you later. Bye.
Bye bye. All right.
Thank
Thank you,
you.
Tabitha, for a good morning's work. We have one final case. Let me see. And Jennifer Hansen will be covering this. It is Omari Tahir Garrett, case 72787, an enforcement matter.
That is correct, Commissioner Ammons, and good job on saying his name correctly. I was going to make sure that you knew his pronunciation, Mr. Omari Tahir Garrett. So the as you said, I have the memo here. Pull it up. As you said, this case number is 72787. And the chair and vice chair, Fred Jarrett, have also received this memorandum that I'm reading from. It was also sent to Mr. Tahir Garrett prior to the hearing, letting him know that this is the information that the presiding officer would be considering today. Mr. Tahir Garrett is being brought today for enforcement for failure to file the C1 and F1 reports within 2 weeks of becoming a candidate in the 2020 primary election, which is a violation of 4217A205 and 700, as the other cases that you've already heard today allege. The reason why this one was pulled out separately is because a complaint was filed by a member of the public, and so we had to pull it out of the group enforcement process and treat it as we do with other complaints. So Mr. Tahir Garrett was a 2020 candidate for governor, one of the 36 gubernatorial candidates this year. He, of course, was unsuccessful with receiving 0.35% of the vote after the primary election. Mr. Tahir Garrett is not a first-time candidate. However, I would note for the record that he is not an experienced candidate, meaning that he hasn't run a full reporting campaign. When he filed in 2015 as a candidate, he chose mini reporting, listed himself as his own treasurer. Mr. Tahir Garrett received the same reminders as were mentioned earlier by Tabitha Blacksmith regarding all candidates who hadn't filed the C1s and F1s within 2 weeks of becoming a candidate or by no later than June 1st of 2020. He also received some additional communication because of the complaint that was filed. He received a copy of the complaint and received some information related to the fact that I was the compliance officer reviewing his case. He also had some issues with some emails. When I had not received information back from him, he hadn't filed and hadn't responded in any way. I did attempt to contact him via phone number and by email. We actually had 2 separate email addresses for him, and service was provided to both of those email addresses. So not only did we attempt to communicate with him through our normal means, which is just emailing him, we also tried to contact him via phone using the phone number that was on a previously filed report in 2015 with the PDC, and mailed hard copies of the hearing notice and have not received any messages back. None of those messages, emailed messages, or mailed versions of any notices were returned to us until Monday, when I reached out to Mr. Tahir Garrett. I'm sorry, Friday, when I reached out to Mr. Tahir Garrett again. I did get a bounce back on one of the 2 emails that we used. So I am confident that he received these documents per the normal process. They were received via email, at least at one of the email addresses that we had on file for Mr. Tahir Garrett. And these are ones that he had provided to us on previous reports or through filing a declaration of candidacy. He provided an email on that. And they were mailed, notices were mailed to Mr. Tahir Garrett at a mailing address that he had provided in the past and provided to the Secretary of State's office when he filed this declaration of candidacy this year. In addition, Mr. Tahir Garrett has not been subject of enforcement in the past, but as of today, we've had no communication at all with him. The missing C1 and F1 reports have not been submitted. There has been no email, no phone number, no phone calls, no communication by mail of any kind that we have received as of today. And I did look again this morning to make sure. And I did attempt to call Mr. Tahir Garrett one more time this morning. Unfortunately, the number that he has provided in the past to us provides just a busy signal. In addition to all of the communication and the lack of response, staff had to have an initial hearing for this case in order to be able to transfer it from an investigation into an open case into a formal investigation so that it could go forward and be heard at this brief enforcement hearing today. And so that was an additional communication that was done with Mr. Tahir Garrett that we received no response. He did not respond and indicate that he was going to participate, and we have not heard from him. The standard penalty for Mr. Tahir Garrett would be, according to the rule, would be $250 per report, so a total of $500 for a first-time violation. The reports were not filed at all before by the date of the hearing. He has not had any enforcement in the past, and of course did not send any statement of understanding or any other information to us. I would like to suggest that as a starting point for Mr. Tahir Garrett. Of course, Mr. Chair, you can suspend a portion of the penalty. It's difficult for this particular case because Mr. Tahir Garrett is he is aware from the past, at least, of his filing requirements. As you've mentioned in the past, it was a little bit easier this year for candidates to file with no filing fee. The filing fee was waived this year. And so it was a little bit easier, hence the reason why there were so many gubernatorial candidates. He had very little opportunity to move from the primary election to the general election. So a suspended penalty might be appropriate given the fact that he has been interested in the political process in the past and might decide to run again in the future. And a suspended penalty might encourage him to file and then pay it. However, I am concerned about his ability to pay given the very limited information that he's provided to us in the past on the reports that he filed as a candidate in 2015. The difficulty with suspensions is that, of course, if the person doesn't file, doesn't pay within the 30 days that's normally allowed for a suspended penalty, then we bring them back to hearing anyway. So I'd like to present that information to you, Chair Ammons, and have you decide whether you want to assess the $250 penalty per report, so a total of $500, and not suspend any of it, or if you want to suspend a portion of it, hoping that Mr. Tahir Garrett will adhere to some of that. So otherwise, we might end up with him, unfortunately, being in a situation where he doesn't file and he doesn't pay, and then we'll be bringing him back again. And then, of course, the suspended portion will come due, and it would be the same anyway. So I'd like to present that information to you and let you decide which would work better. But that is my opinion on his particular case. And if I left out a ton of detailed information because I hoped that you had already had an opportunity to review the memo. But if there's anything that I left out that you need to know before you make your decision, please let me know.
Did you do a search of his previous campaigns? The name is familiar to me as an old political reporter. I don't know if it's because he's an activist in the news or whether it's from campaigns, but you said that 2015 was a race. What was that for? And were there others that are in our database for previous campaigns?
Yes. So Mr. Tahir Garrett ran in 2015, and I apologize. I'll look here as I'm continuing to talk to see what office that was. Part of the reason why his name might be familiar to you is he has been involved in the past. He's also had some filings done with the city of Seattle. Has been a candidate in the past and has also had some additional personal dealings which have caused him to be in the news. And so he is a local candidate that has been involved. So that might be why his name is familiar to you. Other staff members that have been with the PDC for quite some time are also aware of his name from the past, not necessarily because of the candidacy. Of course, we can only go back 5 years for enforcement, so it's also possible that he's run way back, and that would be outside of the statute of limitations. But
yeah, I basically was just wondering about if we can sense his level of vacation with being a candidate and being required to file, and it sounds like he did file the requisite forms in 2015. But if there's anything else to guide us on whether he has been compliant in the past.
Yes, in 2015 he ran for Seattle City Council and did comply and actually filed timely at that time. I can tell you that when I spoke to Polly Grow, who's with the Seattle Ethics and Elections Commission, she was able to provide me some additional contact information for Mr. Tahir Garrett that I didn't have. She was able to give me a phone number to use, and I was able to call and leave one voicemail for him, and then since then have not been able to utilize that phone number again. But she indicated that Mr. Tahir Garrett might not have a permanent residency. He does have a P.O. box that he uses as his mailing address, and so that might add to some of the delay or lack of communication between regulatory agencies like ourselves and this particular candidate. I have not had any personal contact with him. As I mentioned, he hasn't reached out at all, and so Polly Grow with SEEC didn't indicate that he had any additional things outstanding, although she did mention that that the difficulty getting a hold of him might be related to his living situation. So, but we don't know that for sure because we haven't had any communication with him.
Do you think holding this over, do you feel a need to do any further due diligence, or do you feel like we have enough information to assess a penalty?
I'm not sure that holding it over would result in any different level of communication from him. I'm actually not certain that even an order being sent to him via email, and I will also send it through regular mail, I'm not sure that even that level of communication with him will solicit any additional response given the amount of communication that's been attempted by myself and other staff here.
Correct.
I
wish I had more information. I wish I had more information about him, whether his cognitive skills are good and whether he's tracking with the needs So I guess I'm going to rule at this time that he is in violation of RCW 4217A dot 205.700 that carries a $500 penalty schedule penalty for a first time penalty, and then suspend I'm going to say $300 of that, and conditioned on him paying the non-suspended penalty of reverse and having submitting the required receipt, the reports within 30 days, and the non-suspended portion within days. I'm not entirely sure that anything will come of this, but I think we do the best with the information we have, and we can't just comfortable with just suspending all of it and sort of forgiving it. I think it is a requirement of state law, and he has been a candidate in the past, and I don't know what his resources are like, but again, that can't be our consideration either as a tip response. So that's what I will order in this, and that the director will send out the final order to Mr. Taylor Garrett within 30.
Excellent. And Chair Ammons, because you were breaking up so badly, I'd like to just reiterate what I believe you heard, what I believe I heard, which was you're assessing a penalty $250 per report, violations of RCW 4217A 205 for failure to file the C1, 700 for failure to file the F1. You're suspending $300 of that $500 penalty based on the fact that Mr. Tahir Garrett files the missing reports and pays the $200 unsuspended portion within 30 days of the date that the order is issued. Did I miss anything?
And we had
the boilerplate also about not having any further violations for 4 years, or the full amount would be due and payable if all the other things had happened.
And no violations of 4217A for 4 years. Okay, great. Thank you very much. I will make that happen. And of course, we can, if he comes back to us, and of course, he always has an option to request a review of this, of the order. So if he has issues, we can bring it forward to you again. So thank you very much.
Thank you for your work on this. So you put a lot of effort into it, and I appreciate that.
So, and I defer to some of my colleagues here, the compliance coordinators, Tabitha, and Fox, because they also did some of this work through the normal group enforcement process. So it was a very nice team effort. So thank you for recognizing.
Yeah, thank you. Well, I definitely do honor that as well. Is there anything else to come before us today?
I don't have anything, Commissioner.
Commissioner Jarrett, are you still on with us?
Commissioner Jarrett had to leave.
I had meant to offer him the option to hop off at any time, since he's trying to just learn the process more than individual cases. So thank you one and all, and we will be adjourned.
Thank you, Chair Ammons.
Bye-bye.